Yesterday was the first day of the Supreme Court's winter quackdown. Was anybody else surprised when Justice Sotomayor dropped the people's elbow on Deputy Solicitor General? Oof, that lady's got moves. Happy Tuesday, everybody. I'm Brino, and this is the Morning Report on the Federal Courts for December 2nd, 2025. Double tap your screen. Comment whether John Cena should rejoin the federal bench. I used to love his dissents. And watch the first minute right now, even if you're coming back, so we hit the FYP. I'm going to be live again today at 10 a.m. Please subscribe at the bottom of the screen there to keep me going. But for now, grab your coffee. Let's get to the news. We're going to start with JGG v. Trump. Now, this is a case filed back in March, try to stop the Trump administration from flying a bunch of people to El Salvador and dumping them in SCOTUS prison. And there are like 5 or 10 other cases intertwined with this one, including Abrego Garcia. I've lost track. Attorney Dye is the encyclopedia on this case. So on March 15th or 16th, Judge Boasberg, DC's chief judge, issued an order from the bench to halt these planes, turn them around if they've taken off, and none of that happened. After 6 months of appeals, it looks like Judge Boasberg has the go-ahead to start tracking down a clear timeline of exactly what happened that day and in what order and who's responsible for ignoring his directive. Now, some of you may have listened to the hearing just before Thanksgiving where he sort of opened the door on this. Well, the door is now off its hinges. This is happening. So, on Friday, Judge Boasberg issued a short but very important order. The first important thing it says is that the government has told him who they're going to be throwing under the bus here. He asked which official was responsible for the decision to launch those planes, and the government all pointed to Kristi Noem. No honor amongst thieves, I guess, or maybe she's stepping up. Either one of those is possible. The judge also ordered that by this Friday, he wanted everyone involved in the decision not to stop those planes, to submit a declaration about exactly what their role was in the decision-making process. So that should be a fun read. But I need to address one more really important thing here because the government's still asserting that because the Court of Appeals later overturned Judge Boasberg's order, they didn't have to follow it. In other words, they knew at the time that it was going to be unlawful, so they didn't follow it. And they were vindicated later by the Court of Appeals. And this is the argument being sold in some media outlets. So I want to, I can't resist a good story, right? So gather around, kids, while I tell you the story of Walker v. Birmingham. So Walker v. Birmingham is about a group of kids who were protesting Jim Crow laws in Alabama in the 60s. It's pretty redeemable bad behavior under the circumstances. And one day, a small group of them was ordered to stop protesting, stop encouraging other people to protest, stop making noise, just generally a textbook First Amendment violation. These students told the Alabama court that they could go duck themselves. And they said it loud. They said it at a press conference. They went right ahead and kept doing their thing. So the court held them in contempt. And they appealed all the way to the Supreme Court. And the Supreme Court took one look at this story and said, wow, you guys have got one heck of a First Amendment violation. I just wish that you had brought it to us. See, if you had appealed the Alabama court order and brought that to us, we would have some fun tearing that apart. But instead, you brought us an appeal on the contempt order. And the contempt order just says you violated the court's order. Did you violate the court's order? You did? Then why are we here? And the point of this case is that even when the Supreme Court agrees that your constitutional rights were probably violated, you still don't get to decide on your own to just ignore a court order. The court in Walker says, quote, "No man can be the judge of his own case, however exalted his station, however righteous his moves. And this court cannot hold that the petitioners were constitutionally free to ignore all procedures of law and carry their battle to the streets." So, here the Justice Department says, we didn't violate the court's order because the Court of Appeals later disagreed with the order, said we were right and the order was wrong. But it was too late by then. You'd already taken your battle to the streets by then. The damage was done. So this is an extreme example. Walker is an outlier, but it's a great demonstration case. This is why it's one of the ones in the textbooks. Because no matter how sure you are that the lower court order isn't going to be upheld, you still don't get to make the decision on your own. Ever. No matter how high your station. And this is what it comes back to by Kristi Noem in the... Okay, so one more quick case and then we're going to get to SCOTUS. So back in June, the Trump administration sued the entire bench. That's all of the federal judges in the state of Maryland. This is U.S. v. Russell. Basically, Maryland judges were getting so many habeas corpus applications, sort of like emergencies because people were being deported, before the court had a chance to hear their cases, which was objectively unfair. And to make sure the court at least had a chance to catch up, they instituted a rule that every habeas corpus case in the state of Maryland would automatically be stayed for 24 hours, just to give the clerks a minute to breathe. Well, the whole point of this craziness was to deport people before the courts had a case to see if they were actually able to be deported. So the Trumps did not like this rule. So they sued the actual judges, which is never going to go well. And it didn't. They lost, and it was a huge, dramatic loss. And of course, they appealed to the Fourth Circuit, but apparently then they just forgot about it. So earlier in November, the Court of Appeals notified the DOJ that since they had never filed a follow-up to their notice of appeal, the appeal was going to get dismissed. DOJ still didn't respond. So last week, the Fourth Circuit filed a follow-up to that follow-up, letting them know that any chance they had to challenge the order had now passed. The case is dead, and they let it die, so it's on them. Play stupid games, win stupid prizes. Okay, now we've only got one SCOTUS case today, so let's talk about it. Today, the court will hear the case First Choice Women's Research Center v. Platkin, who is the AG of New Jersey. This is a slightly boring, very technical case that probably wouldn't have made it to the Supreme Court under normal circumstances. But hiding behind this boring facade is a really dangerous precedent that may be the reason the court's hearing it. So pay attention, gang. This is a case about nonprofit, or a nonprofit, and one that accepts donations. And when you are a nonprofit that accepts donations, there's a lot of room for shenanigans. You can take advantage of people, and so states have a lot of laws in place requiring people who accept donations from their citizens to file reports and keep them up to date on what they're doing. And often state AGs will investigate nonprofits to make sure they're spending donated money the way they claim to be, make sure they're not scamming people. Well, I used to work in nonprofit law. Part of my job was to defend nonprofits against investigations by AGs and accusations of malfeasance. And I can't tell you any more than that, but AGs should keep doing what they're doing. New Jersey was checking in on this particular nonprofit and asked for a list of donors to make sure they weren't scamming anybody. And they subpoenaed records from the organization. The organization refused to turn the stuff over. It all ended up in court, and the court told them, work it out for yourselves. So the judge never enforced the subpoena. And I know subpoenas look scary on their own, but generally the rule is that until a judge steps in, technically it's just a suggestion. Well, this organization sued under the First Amendment, and so far every court has dismissed their case because they haven't been harmed yet. Nobody has enforced the subpoena, so the case is what you call unripe. It's all theoretical harm. It's not ready for prime time yet, and technically that is the case we're hearing today. Snoresville. The problem is, if this case spills into a discussion of whether a nonprofit, particularly like this one, a faith-based nonprofit, has a First Amendment right to protect its donor lists, this could have a really big impact on how nonprofits operate. And I have a feeling that most people will see this from the other side. In fact, I know for sure because of the almost 50 amicus briefs filed in this case, only 3 are on my side here. But I've worked in this industry. There are some really shady nonprofits out there just draining people dry, and I'm not sure everybody knows that. Also, nonprofits also include political nonprofits like super PACs, and keeping those donor lists private may benefit certain people, but may not be in everybody's interest across the board. Meanwhile, there is a very famous case called NAACP v. Alabama, where NAACP was protected from turning over its membership lists to the state of Alabama in 1958 for reasons. Now, is there a difference between a membership list and a list of people who are actually giving you money? I don't know. But I do hate to see less oversight in this area. It's kind of a hornet's nest. So lean in here, watch where this conversation goes. It could stick to these narrow procedural issues, but I don't think it would have been taken up by the Supreme Court just to discuss that. I think this is probably going to go off the rails real quick. Oh, and funsies. Josh Hawley, the senator, his wife is going to be arguing on behalf of the nonprofit, so that'll be good. All right, that is your Tuesday morning report on the past day in federal courts. I'll be live soon with the Supremes. I hope you guys are ready. Otherwise, have a great Tuesday.